Listen, let me just do them in the order that they're noticed.
This man is not playing around
Defendant's
either.
motion for order to show cause by the state court should not be found in contempt of ongoing willful and flagrant violation of court order dated February 9th, 2024. I did read the motion on all of these. I read all the motions. If there wasn't any authority cited therein, I did review that as well. Ms. Liberty, I went on CMS yesterday and I went on Odyssey. I can't find any court order dated February 9th, 2024, nor any order that you referenced on a motion for rehearing February 16th, 2024. So if someone could show me those two orders.
The other one is, and I think I may have put it in that motion, that you see an order from the homicide, they take the appeal, and I believe it was late December, so then you see orders coming from the tampering case, so that might be where the confusion lies, is there was two motions for rehearing. I filed the motions to compel, we came into court, the court had ordered that they comply with it. They filed a motion for rehearing. If you want, I can pull it up on the tampering case. That's more than likely where it came from.
Is that where it is? I mean, I can pull it up. Are you telling me it's not in 1972 CFN?
Yeah, and that's kind of why initially I had this filed under 2023 because it would be easier for the court to file. The state objected, wanted everything filed under 2019.
And I want to actually take a quick break here because I know some of y'all may not have seen this video from the alleged shooting, but let me play this back for y'all real quick. So we're going to take a quick detour and it's just going to be a 2-minute video. So y'all check this out in case you haven't seen this. This case is taking place in Florida. Let me see if I can get it to load. Y'all see Melly?
Excuse me, you're able to see?
And this is from the first trial. Yeah, it's Melly in the purple shorts right there.
Detective Bertrand, in your experience in collecting and reviewing surveillance footage over the course of your career as a homicide detective, is the time always accurate?
No.
Is it your...
All right, so that's the video where they're alleging everything initially went down or where everything started. As y'all can see, take that for what you will. Then there's an alleged drive-by, and they're saying that Melly was actually the one that shot two of his friends in the car, and they're basing that off of where the bullets are seen, or where the ME is saying the bullets entered and exited, and that's why we're here. There we go. We'll get to it.
Or we can take that one last and I'll take a break and then pull everything up so it's there.
No, just give me a second.
And the retrial is scheduled to begin on September 10th. Yep, so he's gonna be in there another 7 months. Let's skip ahead here. Getting their stuff together. There we go.
It says this call. So I found the order. This is case number 23-1059-46, and Judge Murphy entered an order on February 9th, 2024. It says this cause came before the court on the defendant's motion to compel discovery filed on February 6th, 2024. When the state filed a response, the court held a hearing on February 9th, which granted. Judge Murphy subsequently entered an order denying the state's motion for rehearing. That's on February 16th, 2024. There's only one motion to compel from the defense filed on February 6th, 2024. I'm looking at it right now, I just read it. And I don't see any reference to the 4 items that you put in the present motion.
Would you look and see if there was not another motion to compel possibly a day before?
Well, I'm just looking at Judge Murphy's order. He said this order is related to the motion to compel discovery filed on February 6, 2024.
So there's actually,
That's the only motion to compel filed on February 6, 2024.
so there should be 2 motions for rehearings filed by the state going to 2 separate orders, and then the judge denied both of those 2 separate orders. So there was 2 motions to compel, and I believe in the one motion to compel, it was going directly to the information regarding.
Hopefully time served will factor in for Melly at some point.
Well, did Judge Murphy enter an order on that?
Yes. So if you want to pass, I'll pull it all up so we can read it and make it a little bit more easy. I'll pull it up and go along quickly. But there were 2 motions to compel, and there were 2 motions for rehearing.
Was there 2 original orders?
There should be 2 orders.
Okay, so we'll pass on that.
So the next one would be James.
Look at this guy.
Number 2 is defendant.
That reminds me of somebody.
To exclude James Howe's irrelevant and immaterial detention communications. So you're talking about, this is a motion limited for trial. I mean, I read the motion. Anything else you want to tell me it's supported your motion?
This judge, it was close to, I want to say 84 hours worth of phone calls that were given to us that December. We were set for trial. I was always of the position it was given to us that late in the game in order to make it continue it. Nonetheless, I had a group of students go through those phone calls along with myself and the investigator. When you look at the police report that was authored by Garrett Steele, it starts referencing a investigation that's being done by Danny Polo into this James Howard, and I believe the Albany. He, for some reason, then references James Howard in this police report, saying he was listening to phone calls by James Howard, and then he hears James Howard telling somebody on the phone call that he has to do something for Melly that day. We had the opportunity to depose Detective Polo as well. I asked him this very question. I told him over 80 hours worth of phone calls. There was 1 phone call, and that 1 phone call in this batch of phone calls tells us nothing other than him saying, "Oh, I have to talk to Melly today. Now I have to do something for him. Now I got to call people for him." Nothing at all. During the deposition of Detective Polo, when I started questioning him, "Hey, I went through all these phone calls. Could you please direct me to what phone call I should be looking at? What batch of phone calls?" He then tells me, "It's not this batch of phone calls. It's a batch of phone calls that would go back to 2020 and 2021. We are dealing with the tampering, I believe we're spanning from April of 2023 until August of 2023, somewhere in that time frame. Detective Poole, in his own words, was the only time that he had heard James Howard talking about Melly would have predated the incident, i.e. 2020, 2021. Nonetheless, those phone calls are not in this 84 hours of phone calls.
Dave, can you respond?
Yeah, before we proceed on that, there is still the outstanding issue of whether Mr. Dennis still wants to still be representing him. The city raised the issue for the conflict of interest. The court pointed that out. That was going to be one of the first things we were going to address the issue today. And
Dang, he's taking shots right off the bat.
As long as somebody representing him, then there's an issue to issue that to the party.
I mean, that's his call. I already had that discussion. So I'm sure if there's something that you want to let me know, let me know. Any response to the motion?
Yes, sir. The state filed a written response, I believe it was yesterday. This is one that's properly prepared.
Yo, he straight up just looked this lady in the face and said, Judge, I don't even know she's supposed to be here. So, are we gonna deal with that, or what are we doing? Because I don't know. I don't even know why this chick is talking. That's wild.
In this 84 hours of phone calls.
Dave, can you respond?
Yeah, before we proceed on that, there is still the outstanding issue of whether Mr. Dennis still wants to still be representing him. The city raised the issue for the conflict of interest. The court pointed that out. That was going to be one of the first things we were going to address the issue today, and we still need to address that because obviously if he does not want somebody representing him, then there's an issue to issue that to the party.
I mean, that's his call. I already had that discussion.
The sound should be good. Do y'all need me to turn it up?
Any response to the motion?
Yes, sir. The state filed a written response, I believe it was yesterday. This is one that's properly prepared, but as pointed out in the argument, the state is not required to disclose which calls it intends to use at trial. But other than that, we are going to rely on the responses.
So I did check the docket this morning. I saw no written motion. And it's funny, Judge, that they were starting this hearing off saying they wanted to continue it because they didn't get proper notice. A notice of hearing from, I don't know, almost 2 weeks ago. But in the evening, they filed something before Ms. Buckley went to the hospital.
This is the second time. You need to look at me and address things to me. I could give you a lot of adjectives about what I think of this entire procedure. Funny's not going to be one.
Okay.
So, anything else you want to tell me about this?
Dang.
Judge, I would say there are no
Court is very
material
low.
that would even go to the nexus of witness of room.
Okay, so this one, and I'll enter the appropriate order to be denied without prejudice. I have no idea what is or what is not going to be relevant.
Judge Fiend is fed up with this.
Evidence at trial, there's no way that could. I can't make the state try to case in vacuum. But there's, without prejudice, you can certainly raise the issue. If the state tries to introduce any of these phone calls at trial, the appropriate objection, and I'll give you the appropriate ruling. But in a vacuum, having never heard any of these calls, I have no idea what the calls are, nor do I have any idea what the evidence is going to be at the trial. So that one's going to be denied without prejudice.